Tasmania Police exposed. 763 privacy breaches unveiled. Part 1. Introduction. Amidst Tasmania's quest for justice, the very guardians sworn to protect us, the Tasmanian Police, stand at a crossroads. As allegations of privacy breaches emerge, the foundations of public trust is shaken, prompting us to question who truly watches the watchers. The case in question is a confusing mess, so I've narrowed down the information, only including the facts I believe are relevant. The case itself is not of much importance in regard to this video. I will cover some of the information for background, however our main focus will be the alleged breaches of privacy made by Tasmania Police in regard to this matter. In this video I'll highlight these alleged breaches of privacy that happened not just once, but 763 times during a 2-month period, when police were secretly recording audio and video of unsuspecting individuals during a botched surveillance operation. So without further ado, let's unwrap this complex case, take a look at the implications and how it affects every single one of us. Part 2. The basis for the allegation. In June of 2017, the legal community would be astounded by a case that would raise serious questions. At its core lay a potentially profound miscarriage of justice, rooted in alleged police misconduct. It began with a covert surveillance operation, aimed at understanding an alleged conspiracy to pervert justice. The stakes were high, a case that could potentially expose serious wrongdoings within the ranks. Documents dated the 13th of June 2017 highlighted an application for a surveillance warrant, initiated due to suspicions of a conspiracy. The primary objective was threefold: gather evidence that would implicate those involved in the conspiracy, investigate the involvement of others already identified in connection to the case, and unearth the involvement of any yet unidentified individuals in the conspiracy. Such warrants are not granted lightly. However, as the court analysed the complexities, a primary concern became evident. This is where we delve deeper into the mechanics of the case, the intricacies of the warrant, and the looming question of the sanctity of private conversations in legal premises. Part 3. The warrant and its implications. The issuance of a surveillance warrant is a powerful tool, not to be wielded lightly. The core tenet upon which such a warrant is based is trust. Trust that law enforcement will use it judiciously, with full respect for the privacy and rights of individuals. In this unfolding tale, the use and possible misuse of such a warrant would come under intense scrutiny. The matter of surveillance within Risdon prison was of particular concern. When Constable Jago applied for the surveillance warrant, he assured the court of strict adherence to privacy norms. In his affidavit, he stated that the police would only monitor conversations directly related to the investigation. Implicit in this assurance was a promise that private or privileged conversations, especially those between lawyers and their clients, would remain protected. However, the actual execution painted a more complicated picture. The surveillance devices, once installed in the prison's visitor meeting rooms, remained active continually between the 15th of June and 17th of August 2017. A technical officer responsible for the devices highlighted their continuous operation, and while it was possible to remotely control these devices, in practice they were left running. This meant that every conversation, irrespective of its relevance to the investigation, was not only recorded, but they were live streamed directly back to the police. Over those 2 months, countless confidential conversations, completely unrelated to the investigation and involving hundreds of people that had no connection to the case, were unknowingly recorded. From emotional exchanges between families to critical lawyer-client discussions protected by legal professional privilege, nothing was off the record. The potential for abuse was immense. The mere possibility of these unlawfully obtained recordings being nefariously used was deeply concerning. By leaving the devices continually running, the police effectively cast a wide net, hoping to catch relevant conversations, knowingly infringing on the privacy of unrelated and innocent individuals. And while the police claimed operational pressures and constraints were the reasons for these recordings, the question remained, at what cost? As we peel back the layers of this case, the complexities become evident. The balance between investigative needs and privacy rights is delicate, and as the story unfolds, the quest for truth becomes even more intricate. Part 4. The integrity of the justice system. The foundation of any justice system lies in its ability to ensure fair play, adherence to the law, and the protection of citizens' rights. Surveillance, especially covert surveillance, is a powerful tool. When appropriately used, it can shine a light on the darkest corners of criminal conspiracies, helping to dismantle them and bring the guilty to justice. But with great power comes great responsibility, and in this story, the balance between surveillance and privacy teetered dangerously. The narrative becomes all the more compelling as we consider the players involved. Constable Jago, with his immense responsibilities and the pressing weight of the law enforcement apparatus behind him, was at the centre of this turmoil. His affidavit presented a clear and determined intent to unmask an alleged conspiracy, but but the means to that end were fraught with ethical and legal dilemmas. The presence of continuously running surveillance devices in its meeting rooms raised critical questions. Did these rooms, once considered safe spaces for privileged conversations, still hold their sanctity? At the heart of it all lies the question of integrity. The integrity of the surveillance system, the integrity of those who operate within its bounds, and crucially, the integrity of the justice system itself. The very mechanisms of justice, the principles that societies hold dear, and the institutions that pledge to uphold these principles are under the microscope. As we proceed, we'll explore how these institutions responded when faced with dilemmas that blurred the lines between right and wrong. Part 5, the implications and aftermath. In the vast tapestry of the justice system, every thread is interwoven with the next, each action leading to a ripple of consequences that can affect countless lives. The broader implications of the events at Risdon Prison and the subsequent court proceedings come sharply into focus. By this point, the scale and potential ramifications of the surveillance operation had been laid bare. It was no longer just about monitoring a specific individual or group. The overreach had potentially trampled upon the sacred realm of legal professional privilege, and when such foundational pillars of the legal system are shaken, the tremors are felt widely. The court's role in this saga was paramount. The judiciary had a responsibility to uphold the principles of justice, even as it navigated a path fraught with legal and ethical landmines. The decision to exclude evidence is never taken lightly. The revelations about the surveillance devices, their continuous operation, and the risks they pose to privacy was central to this decision. If unchecked power and potential breaches could occur in such a high-profile case, it raised unsettling questions about more routine surveillance operations and their oversight. But beyond the technicalities and legal jargon, there lay the human aspect of the story. The individuals whose private conversations were unknowingly recorded, the legal professionals who trusted in the confidentiality of their consultations, and the public's faith in a system that pledges to uphold their rights above all else. For many, the case served as a stark reminder that while surveillance is a necessary tool in the modern era, its use must always be tempered with respect for the rights and freedoms that define a democratic society and the rights of an individual's privacy. It soon became clear that this case wasn't just about a conspiracy, surveillance, or the individuals directly involved. It was a reflection of the broader challenges facing the justice system. The tale of Risdon Prison, Constable Jago, and the whole web of complexities that surrounded them is a lesson for all. A lesson about the need for vigilance, accountability, and the ever-present quest to ensure that the scales of justice, even when tested, always find their balance. Part 6, the Supreme Court's verdict and reflection. It's imperative to reflect upon the decisive voice in this saga, the Supreme Court's verdict. The court, having meticulously examined every detail, every nuance of the case, delivered a judgment that echoed the principles of justice and the sanctity of privacy. The court's decision to exclude the evidence was not just about the specifics of this case, but a broader reaffirmation of the values that the legal system holds dear. It underscored the idea that the ends do not always justify the means, especially when those means compromise the very foundations of justice and individual rights. By identifying the significant risks to privacy and the inherent shortcomings in the surveillance procedures, the court made a strong statement on the impermissibility of overreaching, even in the pursuit of justice. The value of privacy, particularly in privileged lawyer-client communications, was underscored as being paramount. In essence, the Supreme Court's verdict was not just a commentary on this particular case, but a beacon for all future cases, where the tussle between surveillance and privacy comes to the fore. It serves as a stern reminder to law enforcement agencies about the boundaries they operate within, no matter the challenges they face or the pressures they're under. In the end, the saga at Risdon Prison serves as a poignant reminder of the delicate balance between security and liberty, and the enduring commitment required of the justice system to protect the rights of all individuals, irrespective of the circumstances. Part 7, the ruling. In a moment, I'll show you some important extracts from the reasons for ruling. These statements make it clear. The actions of Tasmania Police were not justified and were a clear breach of legislation relating to privacy. Tasmania Police would have us believe this was all some sort of admin issue or oversight, and that they had no intention of knowingly breaching these people's privacy. However, I believe the evidence and the following statements paint a very different picture. The statement read, "This ruling concerns the second step in the process required by Section 138 of the Evidence Act to determine the defence objection to the admission of the recording of the conversation between the accused and Stephen Gleeson, conducted in a professional meeting room at Risdon Prison on 16th of June 2017. The basis of the objection is that the covert recording of the conversation was in contravention of an Australian law, and that the proper application of Section 138 of the Evidence Act requires that the evidence be excluded. That provision provides that evidence obtained in contravention of an Australian law is not to be admitted unless the desirability of admitting the evidence outweighs the undesirability of admitting evidence obtained in that way. My ruling of 28th of March 2022 established that the recording of the conversation was obtained in contravention of an Australian law, in particular Section 5 of the Listening Devices Act 1991. That conclusion followed from my determination that the warrant which had purportedly been issued by a magistrate under the Police Powers Act 2006, upon which police relied to authorise the recording of the conversation by a surveillance device, and which would have brought the recording within an exception to the application of Section 5, is invalid on its face. I am simply not persuaded that police took sufficient care to either inform the magistrate of the proper operation of the system, nor to obviate any risks related to the potential for the recordings and/or monitoring of unrelated private or privileged conversations. The public interest in ensuring that such conversations are protected from unlawful surveillance by law enforcement authorities is of significant importance. Balancing all of the above factors, I am not satisfied that the desirability of admitting the impugned evidence outweighs the undesirability of admitting evidence obtained in the manner described. In making this determination, I have taken into account all relevant factors, including the seriousness of the alleged crimes and the effect of exclusion on the prosecution case. However, ultimately I am heavily influenced by the considerable risks to privacy which are inherent in this proposal for covert surveillance, and the failure of police to consider and properly address those risks, and to fully inform the magistrate of the circumstances of the surveillance which compounded those risks. In my view, had the magistrate been properly informed then, even if a valid warrant had been issued, it is highly likely that it would, or at least it should have contained conditions sufficient to properly obviate the said risks. The evidence which was presented fell far short of satisfying me that police had any significant insight into these problems and their importance, nor that anything has been done since to address similar situations. Part 8, Tasmania Police Statement. In all fairness to Tasmania Police, I have included their full statement about the ruling. But before I read this, I want you to pay particular attention to the fact that police have stated the ruling must be read in full, yet they have cherry-picked the parts of that ruling that only support their position that they have essentially done nothing wrong. They focus on the case itself and only briefly mention their incompetent actions and the 763 breaches of privacy. This statement from Tasmania Police, as batshit boring as it is, if it wasn't such a serious matter, it would almost be laughable. Bear in mind, I've already shown you the exact words from the ruling in relation to the issues at hand. Their statement, along with their interpretation and presentation of the facts, further shows a lack of transparency and accountability. Their statement reads, "While this was a technical breach of legislation and Tasmania Police did not listen to any other conversations not covered by the warrant, we acknowledge the importance of our community having trust and confidence in our organisation. As such, we've taken immediate steps to address the issue identified, and a review of procedures to ensure there is clear guidance to police officers in relation to the use of surveillance devices has been completed. In addition, today I'm announcing an independent review by former Solicitor General Michael O'Farrell SC of this matter to ensure appropriate processes have been followed. The report will be made public. While Tasmania Police respects the court's decision, it must be read in its entirety. The facts are: in June 2017, a police officer involved in an investigation into an alleged conspiracy to pervert the course of justice involving Jeffrey Ian Thompson and 5 other persons applied to a magistrate for the issue of a surveillance device warrant under the Police Powers Act. The warrant was sought to authorise the recording of meetings between a prisoner, Stephen Gleeson, and Mr Thompson, or the other persons suspected of engaging in the conspiracy. The application was made in response to information that Mr Thompson and others were attempting to have Mr Gleeson produce false evidence for use in Miss Sue Neil Fraser's second appeal against her conviction for the 2009 murder of Bob Chappell. A magistrate issued a surveillance device warrant on the 13th of June 2017 for a period of 90 days. The warrant authorised the installation and use of surveillance devices in visitor rooms at the Risdon prison complex, utilised by Mr Gleeson. On 15th of June 2017, police installed 2 devices in a meeting room at the prison. They were retrieved on the 17th of August 2017. One device recorded conversations to a hard drive, the other device could be directly monitored by police. The only occasion it was monitored was on 16th of June 2017 whilst a meeting between Mr. Thompson and Mr. Gleeson took place. The hard drive recording conversations was accessed by police on the 21st of June 2017. The only conversation listened to by police was the conversation between Mr. Gleeson and Mr. Thompson on the 16th of June 2017. That was the only conversation retained by police. Whilst the surveillance devices remained in place until 17th of August 2017, no further use was made of their product after the 16th of June 2017. The conversations which occurred between Mr. Thompson and Mr. Gleeson on 16th of June was not subject to legal professional privilege because Mr. Thompson was not acting in his professional capacity as a lawyer at the time or assisting a lawyer. In any event, legal professional privilege does not protect communications made in furtherance of the commission of a criminal offence. While the hard drive may have captured other conversations which were subject to legal professional privilege, they were not listened to or retained by Tasmania Police. The conversation between Mr. Thompson and Mr. Gleeson on 16th of June 2017 led to both of them being indicted by the Director of Public Prosecutions with the crime of pervert the course of justice. Mr. Gleeson pleaded guilty to that crime in March 2018 and was sentenced to 12 months imprisonment. Mr. Thompson pleaded not guilty and his trial commenced before Justice Brett in March 2022. His Honour ruled the surveillance device warrant to be unlawful as it referred to Section 2972 of the Criminal Code rather than Section 2971, which creates the offence of conspiracy to pervert justice. As a result of that ruling, His Honour was required to exercise a discretion whether to permit the evidence obtained under the warrant to be admitted into evidence on the trial of Mr. Thompson. His Honour excluded the evidence based on his concerns that the application for the surveillance devices warrant did not adequately address the risk of surveillance devices installed in the meeting room at the Risdon prison complex capturing conversations between other prisoners and their lawyers. In his judgment, Justice Brett expressed his satisfaction that the police made a genuine attempt to obtain the relevant lawful authorisation and believed, and were entitled to believe, that the warrant had been validly issued before they recorded the conversation. His Honour also acknowledged that while it appears that police did not deliberately set out to break the law, there was also an obvious misunderstanding or ignorance of the significant risks inherent in their task. Tasmania Police took immediate steps to address the issues identified in Justice Brett's decision. A review of procedures to ensure there is clear guidance to police officers in relation to the use of surveillance devices has been completed. While Tasmania Police is disappointed in the outcome of this prosecution of Mr. Thompson, we respect Justice Brett's decision. It is noted that His Honour rejected a submission by Defence Counsel that the evidence considered by the magistrate who issued the surveillance devices warrant was insufficient to justify the issuing of the warrant. His Honour made the following observations as to the sufficiency of the evidence considered by the magistrate. Of course, it was not necessary for the suspicion or belief to relate to an offence to which the accused was a party. However, the evidence in the affidavit does, in my view, provide a strong basis for a suspicion or belief that he was involved in the alleged conspiracy, if not as a knowing participant, then at the very least as a means of giving effect to its execution. Although the affidavit asserts a suspicion or belief that both Gleeson and the accused are involved as knowing participants in the conspiracy, this was not necessarily to justify the issue of the warrant. It was enough to suspect or believe that the proposed conversation and other potential conversations which might take place between Gleeson and persons named in the affidavit during the life of the warrant in the prison would provide evidence of the conspiracy. I am satisfied that the evidence in the affidavit established reasonable grounds for a suspicion or belief of that nature. I welcome the independent examination of this matter and welcome any opportunity to ensure the transparency and accountability of our organisation. The full judgment can be accessed here. Darren Hine, Commissioner of Police. Part 9, Conclusion. So there we have it, folks. To me it's pretty obvious what happened here. Once again we are simply told to trust that the police didn't do anything wrong because they said they didn't do anything wrong, even though the ruling proved they did plenty wrong. The one key point I want to get across is that Tasmania Police made a lengthy statement that barely acknowledged any of their wrongdoings, and then proceeded to tell us a very one-sided interpretation of the court ruling. leaving out anything that would show them in a bad light. I'll let you form your own opinion based on everything I've presented in this video. Feel free to share your opinion in the comments section below. Do you think this was simply an oversight by Tasmania Police, or does this point to something more serious? Thanks for watching everyone, I really appreciate the support. If you like the videos, hit that subscribe button so you don't miss the next one. I've also started up a petition to hold Tasmania Police accountable. If you want to check out the details, there's a link down in the description. Cheers.